What I will be speaking about is the relational aspect of professionals and the work they do. The neighbor principle. What are we here for? And using author's liberty, I decided to, or I could call this presentation Misgovernance Scorecard, Assessing Contribution by Professionals. Because the first thing I saw at that hotel, which I have not named and therefore would be under no liability, is that there was some kind of professional misgovernance that I was immediately introduced to in a room where, without that room, I cannot survive because that is where we eat. As an introduction, and this paper or this presentation arises from a discussion I had with under the auspices of Hezabika Trust, where we were talking about very much the same topic, and Karanja happened to be there and said, it would be a good idea if you came and shared those thoughts. And so those who are there, they find this a bit of a repetition in some ways. In the Hezabika discussion, I said Christianity or Christians are the greatest threat to governance in Kenya. In this paper, I say professionals, after Christians, are the greatest threat to governance in Kenya. And the truth is that we are, as professionals, the greatest threat because we do not want to open our eyes to the obvious things that are right, about doing right. And so I was actually very encouraged by what Caesar was speaking about, Dr. Caesar. And I thought maybe I shouldn't have come after all because he had carried my topic with him. We just do not want to acknowledge that as professionals, we are actually responsible for misgovernance. There are very few unprofessionals, if we can call them that, who are responsible for governance of institutions in Kenya these days. Very few. And so we are the ones who, in this body politic, who are responsible for this misgovernance. Why do I say Christians and why do I say professionals? I say Christians because you will remember that our census in 2009, when they came to your house, they asked you, what are you? Or what is your religion? And you said Christian. And so they logged that, and it turns out in 2009 at 83% of Kenya, of the Kenyan population, not just the voting public, the population is Christian. Now, if you add the other religions, we may come to about 90%. So religious people running this country are the greatest threat to governance in Kenya. And this is, I've just picked this. I'm not even a statistician. I'm actually a CS. I'm a lawyer. I'm other things, jack of all trades. I'm a husband, father. I don't do all these fancy high-level things. But these are things that, this is information that's available to the public domain. I define governance to mean managing events to achieve outcomes. I also mean governance as the health of an organization. And I know although we talk about corporate governance, I am happier to talk about just governance. Because corporate governance, to me, is very limited to, in law, to bodies or entities that are corporate. What about the unincorporated bodies, like the judiciary? What do we do about them? In fact, that's a big question. I spoke with Omariba the other day. What do we do to those organizations or organs that are not corporate? when I talked about the national census, I was trying to come to the point that it is a huge, the largest contribution to the Constitution of Kenya was by this 84%, to the passing of the Constitution. Because even if only 1/3 voted and all the other non-religious people voted, you wouldn't have got the 55% odd that voted for the new Constitution. So we are still stuck with the position that it is we Christians, we Muslims, we Hindus that by and large gave ourselves the new Constitution. And it is these same people who are the professionals. How many are Christians here? It has to be at least 84%. You have no choice because that's the record. Even in the Bible, when the census was taken, it is still a stored record to this date. And so in 2009, if you are around and your hand was up and you said you are Christian, you are stuck with it until you change. So the records of Kenya between in the year 2009 until when Christ comes back will record when in 2099 and in 2160 and in 2730 if it reaches, when they read the history of Kenya, they will say Kenya was an 84% Christian country, 10% other religious people's country. That's what they will be saying. You will not see that we were not Christians. And this is important because it will say something about our philosophical outlook, about who we think we are and what we are here to do. In the preamble to the Constitution, we the people of Kenya, we acknowledge the supremacy of the Almighty God. Really, we are a religious people. We are even proud of our religious diversity. We end the preamble by saying, God bless Kenya. So we introduce ourselves to the world as a religious people. Article 8 gives us the preference and the right to determine our religion, and that cannot be taken or curtailed in any way. Then we have the national anthem. All these, where we invoke the name of God, the freedom of conscience and belief and religion, all these invocations of the name of God are saying who we are as a people. And I'm sure you can already see where I'm going. So the Constitution that we passed places great expectations on us. Caesar called them aspirations. But they are more than aspirations because in practice, you can come to court on the basis of an aspiration and get a remedy. You get a remedy. So there are aspirational aspects and there are concrete remedial aspects in our Constitution. I apologize that I have not put this into a PowerPoint. We have had quite a number of upheavals in the judiciary, and it's not your business to hear my lame excuses, but I'm just apologizing, and please forgive me for not having a PowerPoint presentation. That's what I'm trying to say. Article 3 places an obligation on every single person to defend the Constitution, to respect, to uphold it. That obligation is not even limited to professionals, it's just to everybody. But we already know that 84% of those people are Christians who have that obligation, and the other 10 are the other religions. Article 10 requires us to be bound by the national values and principles of governance. They all bind us. Good governance, integrity, transparency, accountability, you name it. Sustainable development. Chapter 6, Article 73 onwards, give us the leadership and integrity principles openness, accountability, again, public participation. Article 233, we could go on and on. Article 248 even creates independent constitutions to ensure that those things are done. And so we have all these independent constitutions, the JSC, the Public Service Commission, all these commissions and independent offices to ensure that these principles that we give ourselves are complied with. So we have adequate constitutional standards for governance. But we also have, as a people, adequate religious, Christian, Muslim, Hindu principles of governance from our own books of belief. We have a lot, don't we? We have all this, and we are pumped up with quite a bit. Let me give you some examples, anecdotes of professional misgovernance now. As was indicated, I worked with for the government and in the Public Procurement and Administrative Review Board. When it first began, it began as an administrative organ, not under statute. Then it moved into regulations as the Public Procurement Complaints Review and Appeals Board, PPCRAB, and then went under statute as the Administrative Review Board. This was first established as an administrative organ in 1999 during the era of Treasury reforms. At that time, procurement regulations were scattered all over the place in memos, in directives, in circulars, pieces of paper which could not be collated into one. Nobody knew where they all were. Most retirees knew where a good handful of them were because they had been in existence since the 60s and before. So what had happened in public procurement was that cartels had developed, fronted or supported by these people who had insider knowledge of procurement regulations. They were not even regulations then, they were circulars and pieces of paper all over the place. And it was around that time that I was being appointed to chair the board. Case number one, I recall, was it was not the first case that I ever handled, but it's the first case in my presentation. It was a large and very lucrative tender. It was a tender for insurance services, and it was all over the newspapers, as they often tend to be. And so everybody was looking to see how will this board handle. Oh, Joshua was a member later on of the board, so he will hopefully back me up when I have gone and everybody is gossiping. Call Joshua. And a professional, I called him, in the other presentation, I called him Mr. Christian. He was a top officer of state. I knew him very well. He had visible connections with a large church that I also knew very well. I used to be an elder of my own church. But he called me. And he basically told me that this is the way you should handle this procurement appeal. He wanted me to ensure that the outcome of this group of members of the appeal board reach a certain decision. So I told him, okay, there's 9 of us. Have you spoken to the other 9? He hadn't. He thought I could. I told him, in any event, what I suspect is going to happen is that the facts that come before us and the law that we will apply and the known policy that is presented to us is what will determine the outcome. So don't panic. Everything will be okay. All right? After we spoke, the thing was annulled. And he was a very, very unhappy man because he had interests in the then winner, who we annulled. So I became fairly unpopular in those days. These were days when 1999, 2000, we still had the old government, or the other government, and it was not in vogue to do certain things. There was a time, I don't know, Joshua, whether you had joined. In fact, it was immediately in 2003, after the NARC government came in, and we thought we were gone, because they came with lots of get rid of everybody. And so we were there sitting, and no appeals were even coming before us. We were just waiting to see what will happen. Second case is one of a tender where one of the highest offices in the land, I will not mention which. For all these cases, I will not mention the names of parties and ministries and what have you. But in this second tender, the minister called and advised that the board should understand the policy behind the procurement and the implications of the decision that we may make, particularly if it was to annul. Because this was a very, very important tender for the life of the country. You know, like these cancer tenders, we used to be told then, if we don't get this medicine in the country, the hospitals will come to a standstill. And we ended up getting cancer tenders and we stopped them. Not because we wanted to, but because the law and the facts said, stop it, start again. And I don't recall the hospitals coming to a standstill. In fact, there are now more strikes and what have you that have stopped medical treatment than what the appeals board was doing. So the minister called me and told me to take into advisement all these statements that he made about policy. The board found everything wrong with that tender, literally everything. And there was no way it could be revived or kept afloat. And so we overturned it. Our name had gone out because all these big, especially the very large ones, were always in the papers. I don't see it too much these days. But in those early days, you know, there was still the Nyayo thing, and everybody was quite, what will they do? What will they do? Nothing happened after we overturned it. Nothing. So it is possible to do the right thing and just nothing will happen. In fact, something good may even happen. Who knows? Later on, in 2005, this is after the NARC government now came on board, and you remember those of you who were at Uhuru Park. Did anybody go to Uhuru Park in 2002? Put up your hand. Just two, just me and Caesar. That's not possible. Okay, some may not have been born, but those who are born, born and bred and adults and so on, it was an electric place to be. If you weren't there, you missed everything about this country. Because, you know, the air was just literally pumping upwards, and you could be lifted on the cloud of that air. It was a great experience just to be there. You know, we had gotten rid of this government whose tenders we were annulling. And you know, this government over whose shoulder, you had to look over your shoulder before you did anything, before you said anything. And you know, you remember the days you had to wear that little badge and appear before the chief to say, I'm around. Would you like me to offer my services as a university student to you, sir? We can sweep here, we can cut this grass. You remember those days. So we had gotten rid of this government, and there was hope and there was inspiration, and the speeches were electric, and unfortunately mud was thrown around and so on and so forth. But here we were, 2005. I was appointed to the pending bills closing committee. I think this is partly why I don't have a PowerPoint presentation. Some of these things you can't put them on the PowerPoint. But that was not the real reason. So President Kibaki appoints this group led by the former Auditor General, DG Njoroge. That was his number 2. And we are supposed to look at first identify the stock of all pending bills, that is, claims against the government for goods, works, and services rendered but not paid, or in dispute with the government. So there we were, and eventually we came up with about 120 billion worth of bills that we had to look at. After inauguration of the pending bills closing committee, committee, we were called. We used to sit in a cooperative house. We were called by none other than the Cabinet Committee on Anti-Corruption. High power. You remember Murungaru? You remember even His Excellency Raila was there. All the big names were there. And we were told, gentlemen, ladies, we thank you very much for honoring the President's call to sit on this committee. You have a great job to do. Remember, this committee is being formed in 2004. It was actually formed in 2004, although we started in 2005. This committee was formed to look at the bills before 2002, when this government came into power. Don't go any further. 2003 was a NARC government. You remember you were at Uhuru Park? Well, they didn't say that. This is my mind thinking. You were at Uhuru Park and we washed the country clean. The air smells good. This is a new era. So up to 2002, you look at those. Backwards. So after the meeting, the chair met us, and we were very worried a lot because we didn't know what that meant. Those of us who had not had experiences with these fellows, he pulled me aside. He says, basically, what these gentlemen want is that they want you not to inspect them. Inspect the past, but don't look at the present. We looked at our mandate. It didn't say where to stop. So I asked the chairman, what are we going to do? They have directed us. We have to give our minutes to them and our reports to them en route to the president. It was a very powerful committee, the Cabinet Anti-Corruption. So we said to ourselves, the chairman actually said, don't worry, we will find a way. He's an intelligent man. I consider him a mentor to me. He managed to stick in that office from 1966 until his retirement. And if you look at his audit reports, it contains everything that was wrong about this country. And he was never sacked. You remember those are the days you could be told to go home. In the news, 11:30, 12 o'clock, 1 o'clock. So he came up with a scheme. We would meet. We would look at the claim and we would evaluate it and come up with some conclusions. The minutes said, meeting number whatever, claim number this was considered and will be contained in a report to be compiled upon verification. So we churned out these minutes and sent to them 4 times, because the minutes say nothing, they don't touch nothing, they wanted the minutes, we gave them the minutes. And so we never ever gave them a single report of what we evaluated. And you know what they wanted with the reports. Once you know that this claim has not been recommended for payment, you carry it with you and you go to Mr. Contractor XYZ. You see, it won't be paid, mister. You want it paid? We can make it get paid. Just part with half the amount and you'll get your money. That's what they wanted. This is what DG Njoroge, I don't mind mentioning his name because it's in proper light, in good light. This is what he had come to understand about politicians. But this is what they do all the time. So he knew how to deal with them, and we were very grateful. Not a single report. They came to see the reports after they had been to the president, and recommendations had been made, and implementation was along its way. Case number 1, KM Roads, phase 2. Alpha Construction, I'm just giving a name there, awarded 2 road construction contracts for the roads KM and AK. Subsequent variations were awarded by engineer, professional, and in this case, Christian. In the 2 projects, he changed the original contract sum by margins well beyond those set out in the existing procurement regulations. Contract sum moved up on road KM from 399 million to 1.2 billion. Contract sum for road AK varied from 183 million to 694 million. When you look at the documentation making the claim, we found it not payable. Case number 2, again a construction, actually a large number of them are construction companies, where a professional, certified, you can only get a certification from a professional, usually a QS, an architect, or an engineer. 518 million is certified as compensation to the contractor during a period when work was suspended at the instance of the company. How nice. Just give us, this money. It's, after all, ni ya mama yako. You remember? I have a number of cases there, but the interesting one is the one of Treasury Annex. I hope is there somebody from Treasury here? You know Treasury Annex? Which one? Huh? Which one? Ah, you see, you have the wrong one. Is that where you are housed? Is that where you are housed? Oh, I see. But there's Treasury Annex, the real one. A group of professionals claimed an amount of 5.967 billion in respect of the proposed Treasury Annex. That Treasury Annex, between CBS, behind that there's a car park. There's an empty space. Treasury Annex sits there. That's the claim for 5.96 billion shillings. These professionals made the drawings, they said, and the work was begun, they said. Now, the ground was not broken, but the work began because, after all, when an architect or an engineer begins his work, the work has begun, has it not? Were the plans approved? Never. Here, they had entered into an arrangement with some officials in government who had promised them that this work would proceed. And it just never did. So the 5.9 billion shillings was being claimed. Of course, there was nothing to support the claim, and we declined. So these are examples of some of the cases that I myself handled or was involved in. In the executive summary, we did 5 reports to the president, bulky reports because of the amount of work that was done. It took us from 2005 to 2011. In fact, 2012, beginning of 2012 was when the last report was given. We said that the committee has noted several instances where claims have been paid while they were still under analysis. The presidential directive has said all claims to be brought before the committee without payment. While they're under analysis, there are people who have the guts to actually make payments in the ministries. That's where we are at as professionals. That's where we are at as a religious people. That's where we are at. And this is all before the new constitution. That's fine. But because we were very religious, especially after this bad government had gone, we now came and swept them out and brought in this new constitution in 2010 and came up with a new paradigm of governance for the country. But it's not only these kinds of cases that exist. There's also criminal cases where there's professional misgovernance. And if you look at a book there's a book that's on sale in town by a gentleman who was convicted for robbery with violence. You know, that's a life or death sentence. It's actually a death sentence. He's called Thomas Nyandoro. The book is called The Life and Times, I think, of Harold Thomas Nyandoro. The book is available. He has given his story. An innocent person, carpenter, he needs to go to Oyugis to get some stuff to expand his business. So he wakes up early, hard worker, that's his story. Hard worker, he needs to go to Oyugis, so he wakes up very early. 4 a.m. in the morning, he's out there going to look for a vehicle he can catch. He's accosted by people. Reason, or the story surrounding all that, is that a magistrate in his region had been trying to buy the land that belongs to the family. And this guy had put up some resistance and said, no, this is family land. Father, you cannot sell it. The father is an old man, he didn't mind. He was not even in proper state. And so this guy is stopping him. The son is stopping him. And so when this case came before the magistrate, he did not recuse himself. He proceeded with the case. He actually convicted the fellow. And so the story is coming out now, but in 2003, fortunately or unfortunately for him, he was found to be one of the corrupt magistrates during the Rendera purge, and he was removed from the judiciary. That was in 1997. So we have not gotten yet the new constitution. So in the new constitution, or under the new constitution, and under all this new paradigm and the 84% Christianity and religious people and so on, what do we find? We find, for example, in the Standard newspaper, I have carried it here just in case. You know, in governance audit, we are told you have to have evidence. You know, I'm learning a lot. I mean, I'm not a governance guru or anything, but you know, here we are. This is evidence of what I read, not of the content, not of the content of what I read. But you see, the Standard newspaper of April 5th says governors face claims of wasting millions of shillings. Here we are. And inside the story is that over 33 governors, these are people well known to Joshua Wambua, they are going to face the Senate. You remember those people who called us in the Cabinet Anti-Corruption Committee? They are going to face them to explain what they have been doing with these millions. Where are we as a country, really? Many governors are actually professionals. They are accountants, they are lawyers, they are all sorts of professionals. QSs, you know, name it. Even teachers are professionals. Kenya shilling 6 billion feared, wasted on ghost pupils, free primary education. I'm just reading some of the blurbs in the newspaper. Watchman saves lives, seconds to building collapse. That means this building collapsed, and fortunately he had managed, you read the article, did you? He had managed to make a lot of noise around there, warn people, and they came out of the building, then it collapsed. It has something to say or to do with the competence of the engineers and the construction people. And it's across the board, it happens all the time. Now, of course, we blame lack of regulation, we blame lack of law, we blame everybody and everything all the time, except, like Caesar was saying, we often don't blame ourselves because we are responsible. Auditor reveals shocking misuse of public resources by state corporations. In fact, I mentioned some of these ones. This is again 5th of, I didn't have to go very far incidentally. This is, most of these are 4th, 5th of April. NSSF. In 2012, NSSF acquired 8 two-bedroom flats and 3-bedroom maisonettes with servants' quarters at Kenya shillings 178 million. It receives only 66,000 shillings rent annually. This is from the Auditor General. Who did this? Who in is there anybody from NSSF? Sorry, this is public information. I don't mind mentioning the name because I'm just repeating, and there's no court order against me yet. Geothermal Development Company. The contractor has demanded 1.025 billion being acclaimed for loss of revenue on the remaining 24 rigs upon termination of the construction contract, in which the contractor has raised an invoice of 13.5 million. How do you come to 1 billion plus on an invoice? Now, I know how it's done because I have handled a case where the QSs are the experts on this, on making claims, claim evaluation, and claims generation. They are experts on this, and they can proportionately increase the amounts on a daily basis for mobilized but unused material, works, equipment, and so on and so forth. It happens all the time. If there's I doubt, is there a QS in here who is also a CS? They can tell us how it's done. I've done some cases in that line. Another organ or organization, Judicial Service Commission, that one is ours, but it's in the papers, so I'm not saying anything that's not already known. JSC held 61 board meetings, out of which only 31 are supported by minutes. JSC cannot explain the expenditure of 49 million. Further, in 2014-15, JSC spent 127 million on foreign trips and subsistence, printing, advertising, information services, training, and other operating expenses. The 2015-16 figures for the same items increased to 241.4 million. Now, anybody who has a background on JSC knows that they barely have, at least then, barely had 20 staff. So, there we are. NHIF has got a story also in those papers of the 5th of April. Works for the multi-story car park is alleged to have, not alleged, this is the auditor's report, Auditor General's report, escalated by 33.7% from the original 909 million to 1.4 billion. Sorry, to 4 billion. To 4 billion. I heard a rumor that they are going to terminate the construction at floor number 15. I don't know where they have reached. But I heard a rumor that they are going to stop it there and that the price will not change. From 38 floors to 15, and the price doesn't change. And we don't go to Uhuru Park to demonstrate. You know, there are all sorts of other worrying scenarios, many worrying scenarios. Many of you have attempted to get onto a panel of professional in state corporations or in large institutions like banks and so on, to get on their panel so that you can do some work for them. I remember doing it in the days of practice. And you know what used to happen? I don't know whether it still happens as of now, but you would have to speak properly to certain people to get onto the panel. I mean, I made it a practice never to work for state corporations at all, because it was just impossible. I did one piece of work for NSSF, and it was not paid for eventually, and I was very happy it wasn't, because the name NSSF has problems. Just the name. So I'm glad I cannot put it in my CV. I didn't. So I did not ask for the money because of what I was told I must do in order to follow payment for the work I had done. And my documents, incidentally, are still being used in that particular job. But that's where we are. I understand that in state corporations and in some of the these government agencies, when you are appointed from outside there, you are required to contribute into some fund. I know we are going to be very quiet about this now, but we know that there's a contribution that's required. Elections are around the corner then, and they're now coming again. So if you're going to sit on this board, you have to make this contribution to this fund. I remember I have some intimate knowledge of, as both a lawyer and a practitioner in that area. I will not mention which it is, because if you trace my CV, you might find what I am talking about. But who ever heard of HEDAM? You know what HEDAM is? Yeah, let's not say it too loudly. I was aware that on Thursdays and Fridays, briefcases would be removed from a safe, packed nicely, and a gentleman who looked like a driver would collect the briefcases. The account that was always debited was HEDAM 1, 2, 3, or 4. Just go back in history and you'll know what HEDAM is. And I'm not talking about a company whose name starts with a P, not that one. Not that one. Actually, in those days, many companies had HEDAM accounts. Many organizations had HEDAM accounts. Those accounts were where the slush funds were kept for distribution to the powers. And we have not really changed. And what I am asking is, are we professionals? Are we not Christians and religious people? Are we really not the salt and light? As religious people, we bring others to our religion because we shine and we draw the light. We reflect the good of our religion. As professionals, we have cutting-edge expertise. So we draw people to us. That's why they come. Nobody can do CS work unless we are CS. They come to you, they have no choice. We are the light. We are. In CS work, we are the light. We may need to make an anthem that we are the light, CS Omariba. When I have left and the gossip stops, make an anthem. We CSs are professionals. We are the light. Nobody else can do it. We are the light. That's why Christians are called the salt and the light of the earth. That's why professionals are given the privilege, sole privilege, of doing certain things for the nation that nobody else can do unless they become one of the light, one of the members of the salt. I have even quoted some verses and so on, but I will not go through all those verses. I'll just say this. Instead of being the light, what do we see? We see professionals and leaders who are greedy and gluttonous. They have engorged bank accounts. Frequently they die, and they cannot take them with them. And then we have lawyers who have to administer or to take up cases for the administration of those estates, who end up having all that money, and the legacy you have left is poverty to the next generation. We see professionals and leaders who behave just like the matatu culture. We hate the matatu culture, generally, because they obstruct the road, they stop anywhere, they overtake you, then stop, they reverse into you, and they do. If you have an accident with a matatu, you can't win. Really. I mean, nobody wants to be involved in an accident with a matatu because you know that you cannot win. I had one, it was long ago, it was in the old days. I'm driving on Enterprise Road. Was it Enterprise Road? It was in the days when I used to go to industrial area. I don't go there any longer. But I was driving, of course, on my lane. There's another car driving on the opposite of the lane. Then this matatu is actually right in the center of the two lanes. And in those days, the roads were really quite narrow. And so he comes and he hits me. He's trying to slide between the two of us. And then we stop. The culture was not as bad then as it is now. That was the good culture, the good matatu culture in those days. They stopped and they spoke. So we had a chat. He says, kama ungesonga tu kidogo pande hii, na huyu mwingine asonge kidogo tungepitana. That's matatu culture. And that was in the good days. It was in the 80s. Soon after I got my license. We are intent as professionals to get there first, to leave everybody in our wake, take every shortcut, like a matatu. That's what we are. We have a professional matatu culture. We are not intent on servanthood at all, despite the religion that we have pumped in us, the constitutional paradigms and standards and principles all pumped in us, which we passed. We see professionals and leaders given to hypocrisy, ready to use every shortcut to gain, even to make fake projects, Treasury Annex B, for example, in order to justify the use of money to benefit us privately. We see professionals and leaders who seek the blessings and not the blessor. Somebody blesses us. We are religious people. You know who is the blesser, don't you? I mean, 80% of you raised your hand, so you know who the blesser is. We want to be understood, not to understand. Until the day comes when we professionals are ready to take misgovernance by us as individuals. Caesar spoke about this. As individuals, not even as an institution. The institutional bit comes later. Until the day that we are prepared, nothing will change about the national misgovernance and the rot that we are continuing to see every day. And our national anthem will have absolutely no meaning at all. Let me talk about nominal Christianity, because it helps me and it will help us to understand nominal professionalism. You follow what I am saying? A nominal Christian is a person who says, I am a Christian, but does everything that is unchristian. In other words, you have the philosophy, but you have no practice. A nominal professional is the one who carries his CS badge big. I see a number of them. I was given one, I decided to put it in my pocket. I don't even know whether it's still here, it's probably been taken. But we have this badge, it shows the institution. Jesus saves, FCS, CIS, PPQ, ACIAB, all these things. We have the backing of profession, but we have no practice of profession. There's a lot more I could say about, there's something about the Ndungu report I wanted to say, but I don't want to overextend your patience. Let me make the next point, which is the blame game. The blame game we play says there is insufficient law or regulation on this point to enable us to know what is right and what is wrong. See, we can regulate the matatus properly, isn't it? Like, we need bigger speed bumps. Is that regulation? We believe to a certain extent that everything that is wrong because of either somebody else or some wrong system. It is never about us. Most of the time, we talked about introspection at the beginning. Do we have sufficient regulatory frameworks in this country? I wonder. My view comes from an experience we had. I don't know, Joshua, whether you are still the public procurement, whether you were the board when we were working on the first regulations and then the act. Did you find you were there? We had just come from, we are doing transformation in Treasury, and we are coming from this era to change. The Public Procurement and Administrative, the Public Procurement and Disposal of Assets Act, when we were working on it from the point when we made regulations of it before, when it was an administrative body. That act underwent 22 editions before it became law. 22. Because we were so suspicious of the looters and of everybody who was doing, or we claimed was doing wrong. 22 editions. How much better a statute could you get? It's more than the Constitution. Only, of course, not at the same scale as the Constitution. 22. I'm not sure there's another act that underwent 22 editions of stakeholder engagement. You come up with a document, you do stakeholder, Kenya School of Monetary Studies, KICC, wherever you went, there was always something to amend. It was so serious that the suggestions made by the public that there should be a member of the public sitting in a tender committee was actually brought and put in one of the editions. A member of the public to sit to see how these guys doing this procurement. And this is notwithstanding the fact that this act was actually based on the international model law, UNCITRAL model law on public procurement. So it is an internationally accepted document. You bring it here, it's gone through, the UN takes years before it passes anything as a model or uniform law. So it comes here and we want to take it for another round of verification. Between 2010, the new constitution coming about, and 2017, we have had 161 new statutes, acts of parliament. Over 185 pieces of subsidiary legislation, rules and regulations. Roughly 10 statutes per month, isn't it? I think we are saturated with law and frameworks. This country has the Grass Fires Act. You've come across the Grass Fires Act? You just can't burn grass around the way you do. You are breaking the law. You have to write a letter, a written notice to your neighbors and to the administrator in charge of the region. You say you are starting a fire in your compound. You are breaking it all the time. We have so much regulation. Cattle Cleansing Act. We have a Cattle Cleansing Act. You're supposed to clean your cattle in areas that are designated. So if you have cattle and you've not been following the Cattle Cleansing Act, you don't blame the law. It's there. It's waiting for you to comply. Some of you have probably in your law studies dealt with the Witchcraft Act. Some don't know it exists. There is a Witchcraft Act, just in case, those are here in some parts of the country, it's very popular to claim they are witches, but there's the act. There's the Witchcraft Act. It regulates against persons who use witch medicine, I'm quoting, articles and artifacts and charms with intent to injure. And there's even a fine. And it's not big, it's 150 shillings. But you can be jailed for two months. So that's heavy. So we have law, we have too much of it. We are saturated. It's just a question of compliance. I'm really coming to the end now. But there's one thing I want to talk about, and that is ADR. And ADR is not alarming drop in revenue or alternative something else. It's alternative dispute resolution. Because we are Christians, I will quote from the Bible. 80%, isn't it? So I can quote. I'm sure Hindus have a similar provision, and Muslims, I'm sure, have from the Quran. But if your brother has something against you, leave your gift at the altar and be reconciled. Don't let the matter go to the judge. That's what the Bible says. But instead we want to take everybody to the judge. Now we have too many cases. Our backlog is growing by the day. Around August last year, a case came before me, Supreme Council of Muslims of Kenya, were being sued by 3 groups of people from different parts of the country. The council was doing elections, and these 3 groups from different districts in the country felt that they were overlooked because they were not given the opportunity to do the election for their delegate, which means when the council does the national election, their delegate will not be able to vie and will miss a position. So the case comes before me, it comes under certificate of urgency and what have you. An injunction was sought against the holding of the election. To me, that was a religious dispute, or a dispute amongst brothers in an organization of brothers. They are Muslims. What I decided to do is to ask them to go and resolve this case out of court. But they had lawyers. And lawyers don't normally see things the way everybody else does. I'm speaking as a lawyer also, because I have a brief, and I am trained to look at the brief, not the stories around, but the brief, and to see whether there are rights and obligations which can be protected. So the lawyers protested. I told them, come tomorrow. They came the following day. I insisted, this is a case amongst brothers. It can be resolved amicably. I am sure of that. I am sure I have seen other cases of this type resolved amicably. We had a discussion, and I now became somewhat of something of a mediator. Not official mediator. Fortunately, the clients themselves were present in the second meeting. When I told them to come on the second, they were present. So they heard me speak, and they were very, you mean we can resolve? So I let that one gentleman speak. He said, Judge, I have not put the proper accent because, there's a way Swahili is spoken. And I said, yes, it can be resolved outside, and even your lawyers will tell you, isn't that so, counsel? And he agreed it can be done. And I quoted to them Article 159, and they heard me, and they said, kitu muhimu sana. In 3 meetings outside of the court, they were able to come up with a consent. I insisted I'm not going to take this through litigation, and I will not write any ruling. They came up with a consent. They held their election eventually in October. This was August. The election was finally held in October. When we recorded the consent, I'm a Christian, they are Muslims, they say, my brother, I let them speak, not through counsel themselves. They blessed me, they wished me good life, health, strength. And I believe I will live a long life. Quarter next, we are doing currently quarter next mediation. We have a pilot project that we just concluded, and we now have a task force which is working on rolling out quarter next mediation as part of playing our part under Article 159 to promote alternative dispute resolution. And I'm so happy I see these days many contracts with a provision, a clause there that says, should there be a dispute. I even saw it in the engagement letter, the government's auditor's engagement letter. It has a provision there. Should any dispute arise between the client and the auditor, the same shall be resolved amicably in the first instance, which failing arbitration, which shall be final and binding. It's going, more and more people are doing it. I hope the professionals are pushing that line, because we're talking about governance by professionals. That's a constitutionally promoted paradigm, which we must also promote. When I spoke at Hezabika, it was a church-based meeting, much on the same topic. At the end, they passed a resolution. They're going to have try to put together an ADR setup. It was not very clear from the way they said worded the resolution, but I think they are working on it now. And that pleases me. I think it's the right way to go. That's what professionals do. To conclude, I think the words professional, the words Christian, the words religious person, we use them nominally. We use them as labels because of what we see ourselves do to one another and to our country. I think, secondly, that the governance tool should include something of a requirement for organizations to have an ADR provision in their constitutive documents. Because that is promoting good governance, it's promoting relationships. We talk about it's not just about the bottom line. It's about more than that. It's about living together as neighbors. If it had an ADR clause, I think that would be a positive factor, wouldn't it? Thirdly, is just to encourage professionals in here, myself included, to wake up and take the bull of governance by the horn. We can, and we can succeed. And nothing will go wrong. You will live the next day. If the old dispensation did not remove that little board, we are just how many? We are 7 in the first instance, in the public procurement, then it was called, it was not even yet, it was not yet PP Crab with Joshua. Before PP Crab, it was called another name I can't, it was a long name, I can't remember it. But that little thing, that little cupboard, it was constituted by the PS. It could just have been, you could have just written a letter saying no longer, you are not there. That's how they behave like that, isn't it? They can just say you are not there anymore. And then you just don't come the following day. But here, you are a CS, you have the law behind you, you have experience, you have exposure, you have profession, and we are all behind you, and the generation after us is behind us. It's just that we don't really believe it. So those are just words of encouragement. There is hope. Not all is lost. There are many who are on this straight and narrow. Yesterday that Karanja was talking about, I asked in response to that question, of that gentleman who said he is going to stay, he said there is another way. So I told him to develop, at least for purposes of governance discussions or for academics, to develop that theory, because Karanja had developed the theory that there is a broad path and there is the narrow path. That's biblical, isn't it? The broad way and the narrow way. Broad leads to destruction, the narrow leads to heaven and everything good. This gentleman thought that there is another way. You don't have to be on the broad and you don't have to be on the narrow. If you're on the narrow, you get sacked. If you're on the broad, you're in trouble. He thought there was a third way. So I told him, I suggested that we develop a concept, that theory, and discuss it, because I don't know, maybe there is. But thank you very much for giving me your ears and your time. God bless.